California Penal Code Section 288A is defined as willfully touching a child with the intent to either arouse yourself or the child. Now, the touching could be on bare skin or through clothing, and there doesn't even need to be actual arousal for this charge to be proven if there was just the intent to arouse. Also, the consent of the child is not a defense of this charge. Some examples of defenses to lewd act with a child would be the touching was incidental. So some examples of situations would be maybe where you're helping a child bathe, or you're helping a child change clothes or get dressed. Another example would be where you're falsely accused. And we know that even children sometimes can falsely accuse adults. This can happen maybe where we have an overzealous detective or law enforcement investigator who coerces or encourages the child to make false statements. The consequences of being convicted of lewd act are very serious. First of all, it can entail lengthy prison or jail time. But more importantly, a conviction of lewd act on a child would cause you to be required to register as a sex offender. This is a life-altering requirement. It's also a lifetime requirement. As a registered sex offender, you may not be allowed to live near schools or parks, maybe churches, and you might not even be allowed to go to schools or parks or churches or concert venues or other places where children and young people are known to congregate. At the Kann California Defense Group, we know how important these cases are. We know that the quality of your life going forward and your freedom can hinge on the outcome of this type of case. So if you or somebody you know has been charged with lewd act on a child, give us a call and we can discuss the various ways in which we might be able to get your case reduced or dismissed.